Your Honor, we can't.
Okay, guys, you get it?
Yeah.
He gets to lead this. He either gets to bitch slap them or they get to bitch slap him. He's choosing to bitch slap them. This is what I want you guys to start doing.
It's his courtroom.
Yes.
Your Honor, when you build a house, you build it on a solid foundation. We cannot continue because we don't have the solid foundation here, and we have no reason to actually have this forcible detainer hearing. There's no grounds for it.
Okay. All right. Duly noted. Let's see if we can move on a little bit.
Your Honor, I have to object. I have to object. We need to find out. We need to go back and have the plaintiff answer my original question. With all due respect, Your Honor, again, I move this court to have the plaintiff stipulate and admit on and for the record under penalty of perjury and for my future appeal as to whether or not they are the creditor and the holder in due course.
Okay. The court has heard you. The court grants your request. Plaintiff.
Yes, sir, Your Honor.
Plaintiff.
Yeah, Your Honor. Yes.
Stipulate and admit on and for the record. Is your defendant claiming to be the creditor and or the holder in due course? Yes or no?
You said defendant.
Or plaintiff, I'm saying. Yeah, thank you. Is your client the creditor in this case? Hold on.
Wouldn't he be objecting to that? Because it's not the client. He's asking him to.
No, he's asking, he wants to know if the client.
Yeah, I would. Your Honor, that's not the issue in front of the court today. The fact is, Your Honor.
Yeah, you do that, you'll be going to jail.
Bailiff.
Was it Cheech and Chong bailiff whack his PP? Mr. Pabilski, it's my courtroom. Do you understand this?
Yes.
I'm asking you a very simple question. Is your client the creditor in this matter?
I can't stipulate at this time, Your Honor.
Okay. Mr. Pabilski, is your client the holder in due course in this matter?
We are the holder, Your Honor.
Stephen, right then.
Yeah, I object, Your Honor. The question was the holder in due course.
Okay, Mr. Pabilski, I will give you one final opportunity to answer this question. It'll be a yes or a no, or you have insufficient evidence to make a determination or a belief. Is your client the holder in due course in this matter?
I have insufficient evidence to enter a
Very
yes
well.
or no.
Very well. Okay, Stephen, you have your answer. We shall continue this hearing.
Your Honor.
Stephen, if you don't like the decisions and the adjudications in this matter, you can take it up in your appeal. It is duly noted for your appeal. But we must continue on this hearing. We have other people and other cases after this. Do you understand this?
No, I don't understand, Your Honor.
God, why don't you teach a class?
I don't understand how.
Your Honor, I move, based on what the plaintiff just said, I move for summary judgment with prejudice. And, Your Honor, pursuant to the crimes committed, pursuant to 18 U.S.C. Section 4, I move to have the plaintiff arrested for felonious acts and ARS 13-3884 at sequence. I hereby place him under arrest for felonious acts he has committed to ARS 39-161 and others. Your Honor, I've arrested him and take him into custody.
I object, Your Honor.
Duly noted. It'll go to the weight. Mr. Sontag. Okay. As to whether or not that's a lawful arrest, that will have to be adjudicated elsewhere. We are not placing anybody under arrest in this matter right now.
Well, Your Honor, I don't care if he either just leaves or he's arrested. I don't care either way.
No, you placed him under arrest. Stephen, you placed him and said, Your Honor, I placed him under arrest. I know felonies he's committed. So he's under arrest. If you're going to choose to let him go, Your Honor, if you want to let a felon that's been arrested go, that's up to you, Your Honor.
Right.
We have the right to arrest somebody in the court.
13-3884, sure you do. Does he know that he committed felonies? That's it. If you know somebody committed felony, you don't even have to
What is
see
the
it.
felony he personally committed, the lawyer?
He's an accessory to the filing of the fraudulent documents.
Oh, okay.
Now, can't they also reverse that and try to arrest us?
For what? We didn't file anything. That'd be false arrest.
Fraudulent documents into the court.
What?
He's entered fraudulent documents into the court as evidence.
Yeah, you can do that. Otherwise, otherwise a prosecutor could never enter forged checks in the court. I'm not worried about that. It's filing in the county recorder's office. Okay. All of this being said, all of this is duly noted. We are now going to continue this hearing. Do you understand that?
I do not understand, Your Honor. I don't even understand why we're here, why we're having this forcible detainer hearing.
What about this do you not understand?
I don't understand any of it.
Okay, Stephen,
Yes.
continue it on. Say, I don't understand. You're allowing them to steal my property by committing crimes against the state and
Yeah.
filing
I
false
don't
documents.
understand, Your Honor. You're allowing them to steal my property with fraud and forged documents filed in the county recorder's office, and
I don't understand
I
how
don't
you're allowing that
understand.
to happen.
I don't understand. I was never given a loan. I don't understand.
Okay.
Object, Your Honor.
Do you have something in evidence?
Foundation.
Do you have my affidavit in evidence yet?
Yes.
You filed it?
Yes.
Okay.
Okay, okay. I'm not going to allow this to be turned into a circus. Does everybody understand that? Plaintiff, do you understand that?
I do, Your Honor.
Defendant.
I don't understand, Your Honor.
I don't understand how they can divest me of my
Okay. Then let me explain. Plaintiff is going to give their opening statement. All of your objections are duly noted. We now note that you're objecting to not being granted a jury trial. We object to
Your
the
Honor, I
whole...
object to not getting the jury trial.
Duly noted.
Okay.
All of your objections are duly noted. Now that we've duly noted them, you need not do it again. You understand that?
No, I do not understand.
You guys getting it?
Oh, yeah.
What am I doing? He's kicking my ass, so I'm just continuing in the same circle.
Can I speak?
Yes.
Friend of the court?
judge will say, then I suggest you get an attorney because obviously you don't understand court procedure.
Okay, and that's very good.
Yeah.
Yes, then, Stephen, if you don't understand this, perhaps you should get an attorney.
Your Honor, I've chosen to represent myself in this
But
matter.
if you don't understand this hearing, then
No, I understand.
No. I
No.
don't understand how they can divest me of my property. That's
Yeah, I don't understand how they can divest me of my property.
and I don't understand how you can force me to get an attorney, Your Honor.
And I don't understand how you can force me to get an attorney, Your Honor.
Okay, I'm not forcing you. Understand, for the record, I am not forcing you to get an attorney. I am advising you that it might behoove you, it might be in your best interest to get an attorney. Do you understand that?
No, I don't understand.
how they can divest
Why do you not understand that?
I don't understand how they can commit fraud and divest me of my property
By using criminal
by
acts
using criminal acts.
against the state of Arizona.
And also, Your Honor, I don't
No,
understand.
finish what I fucking said.
Okay. Against the state of
By
Arizona.
committing criminal acts against the state of Arizona.
The state of Arizona, this court, the IRS.
Okay. Enough. Plaintiff.
Thank you, Your Honor. The questions that Mr. Sondag has brought up is irrelevant in this hearing, Your Honor. It's already been determined that we are the owner of the house. We would like to take
Your Honor,
possession of it.
I object. Facts not in evidence.
Certainly evidence that's what was ruled on, Your Honor. We just did non-judicial foreclosure, which was approved by this court. How can you say it's not?
Object. I object, Your Honor.
Peanut gallery, shut the fuck up. Okay, is that your opening statement?
Well, the statement.
Marty.
You know, you could say, I comprehend, but I do not understand how you.
I would even stay away from that. Just don't, because he's trying to lead you down there. Okay,
Yeah,
finish.
Your Honor, it's already been determined, Your Honor, in previous
Right
hearings
then.
that
Ron, I object. The plaintiff has recorded fraudulent documents in the county recorder's office to accomplish what their schemes and frauds.
Okay. All right. Is that good enough for your opening statement?
we have to think about this a minute.
He just gonna. So, Your Honor, can we just get on with it?
Your Honor, can't we just get on with it? Okay, this is all water under the bridge. This happened before. This is a separate issue, Your Honor. It's already been determined that we
object,
are
Your
the
Honor.
owners of the house. We would like to take possession of our house, Your Honor.
I object, Your Honor. I am
Okay.
I am the real owner of the property.
Okay, Mr. Sontag, we're gonna continue on with this, so please give your opening statement. Please try to make it brief. We've already spent way too much time on this matter. Right then, if a judge ever says he spent too much time on this matter, very important legal phrase, and you better be writing this down. If I gotta say this again. Your Honor, are you rushing me to judgment? Are you rushing this case to judgment? And why are you rushing this matter to judgment? He's toast at that point. He's toast. He better just figure out he can be here the rest of the month. This hearing can never end if you don't want it to end. Because at that point, it's yes, Dan.
Say it
It's called
again.
a rocket docket.
Yeah.
Can you say it again?
Your Honor, are you rushing me to judgment? Are you rushing this case to judgment? And why are you rushing to judge this matter? Very well, Stephen. Please give your opening statement.
Okay.
Because at this point, judges better shut the hell up and let you do whatever you want. Go ahead and do your opening statement, please.
Okay. Your Honor, I hereby again demand a jury trial, and with all that said, I will make my opening statement without waiving my right to a jury. Again, Your Honor, I declare viet armis. Your Honor, I purposefully am reading from a script that has been written, signed, and notarized to ensure that all my statements remain on the record and to ensure that no accidents, loss, or tampering occurs. This will also be used as evidence should an appeal be necessary or at the jury trial that I am demanding. It will become evident that the fraud outlined below will swing the preponderance of evidence completely to my side. Your Honor, according to Arizona Rules of Civil Procedure 17A, we need to move the court to show ratification of commencement. We need to know who we are fighting in this forcible detainer. Right before the foreclosure, both Chase Home Finance and Titanium Solutions, representing Freddie Mac, were coming at me at the same time as lenders. I need to find out who the plaintiff is. Does the plaintiff have standing and who they are? There is a 100% chance that the wrong guy is sitting at the other table. Because of this, we need to start at the beginning, verify everything, all papers, all signatures, and notaries. Since I am under oath, sworn to tell the whole truth and nothing but the truth, I expect to be able to read this without interruption. Any interruption by the plaintiff will be an attempt to lie to this court. The fraud is massive, and I even attempted to notify the plaintiff on 3 occasions by registered and certified return receipt mail, but he chose to file a complaint, either indicating stubbornness, ignorance, or that he is a party to the fraud. I made numerous attempts to yell the fraud, but instead of doing due diligence, postponing the forcible detainer, the plaintiff chose to plow ahead and forced me to bring the fraud into the court. I added some of these things.